Okay, so we just finished talking about malicious prosecution and have more torts to talk about. So now we're talking about private nuisance. What is private nuisance? Private nuisance is when others interfere with our right to enjoy, to use our own property. So simple examples here would be, my neighbor listens to music, loud music, late at night. It's an example, simple example of private nuisance. It's called private nuisance because there's also this tort called public nuisance, but we don't discuss this in this course. So just to let you know. But that's a simple example. Now, courts usually they require you before you sue that you try to solve the matter out of court. So my neighbor was listening to music last Saturday, 2 a.m. until 4 a.m. So I would contact my neighbor. I would eventually contact the strata manager if I live in a strata. Then if nothing is successful, then I would be able to sue my neighbor. And usually compensation is low for this. But it's gonna depend, compensation usually depends on the damage I suffered or the victim suffers. Another example could be the same dry leaves in the fall, I told you. So instead of now throwing the dry leaves in the neighbor's backyard, what you would do is you would put fire in your dry leaves and then ashes and smoke would go to the neighbor and the neighbor wouldn't be able to enjoy their patio or their swimming pool. That could also be an example of private nuisance. Okay, so our property, our right to enjoy our property is interfered with. So we could sue. All right, defamation. So defamation is here in this intentional torts chapter, but defamation can be both intentional or unintentional. So maybe you made a mistake. You made a mistake and you called your neighbor a drug dealer, and they are not. If you called your neighbor a drug dealer and others heard, others listened to that, your neighbor could sue you for defamation. So defamation is this detrimental statement, usually false. And I say usually false because sometimes, let's say Brazilians have a bad reputation in the lower mainland or in Canada. And then you say out loud, hey, this Brazilian instructor. Yes, I'm Brazilian. You are right. It's a true statement. However, because the way you said, oh, this Brazilian instructor, you were trying to attach my credibility potentially to this bad credibility Brazilians have in the lower mainland. So that's why sometimes a statement may be true, but still detrimental. Okay, but in most cases, it's going to be a false statement. So when there's a false statement and that statement is spoken out or published, because if it's only you and I in the classroom, no one else, and you call me drug dealer or this Brazilian instructor, I can be mad at you, but it's not defamation because no one else heard that statement, right? So others, at least one more person needs to hear, needs to read the defamatory statement, okay? Then that's defamation. Now, it may be slander if it's a spoken. That's why I underlined the S and S here for you. So slander, spoken. And the idea, both slander and libel, they are defamation, but the idea here is just to differentiate a defamatory statement that is spoken in slander from a defamatory statement which is written or published online. Then they will be libel. If it's online, it could be cyber libel. Okay, so you should know those words, but both slander and libel, they are defamation. Okay, it's just a difference because of whether they leave a record or not. Now, for slander, usually you need a witness because slander is spoken. And if you don't have a witness, or if the person who listened to cannot or does not want to be your witness, probably you can't prove it in court because it's spoken. Okay, now when it's libel, because it's written or published, then you have a permanent record. Okay, then it's easier to prove in court. You had a question?
Yeah, I know that a lot of the publishers have an opinion article.
Mhm.
And if they, let's say, state company names, and it turns out to be false, that's a good example of libel, right?
Could be, it would come under product defamation. So if it's about a company, service, or product, then it's product defamation or injurious falsehood. And yes, could be. Could be. We'll just discuss about the defenses, and then I'll let you know. I can tell you right now. There's this public interest responsible journalism defense. This is case law from the Supreme Court of Canada. So if the journalist was responsible, and if the matter of the article was in the public interest, let's say corruption or something, it's in the public interest, but still it was defamatory, they can still get away from the defamation lawsuit because they would show in court that they published that article in the public interest and they were responsible. They eventually gave an opportunity for the victim to give their side of the story, but the victim just refused. They don't want to talk to them. So they could get away from it eventually. And also another defense is fair comment. So we can have our opinions. Remember freedom of opinion from the charter, freedom of expression, freedom of opinion. But remember that those freedoms, they are usually related to the government, so that the government doesn't abuse on us. In other words, that the government does not censor us. But also for defamation, so we can publicly criticize others. You can go online and you can criticize me. You can criticize the way I deliver this lecture. You can criticize my exams, my assignments, anything. It's your opinion, that's fine. But you cannot issue your opinion based on a false fact. If you issue your opinion on a false fact, João is discriminatory in class. This is false. If you don't prove this is true, you will be sued for defamation and you may have to pay compensation. Okay, so we can't publicly give our opinion, criticize, but based on true facts. Okay, not on false facts. Now, if you prove your statement is true, again, I called my neighbor a drug dealer during the Strata meeting, and my neighbor sues me for defamation. And if I prove in court that yes, my neighbor is actually a drug dealer, then I get away from this defamation lawsuit. My defense is valid because it's a true statement. Okay, and there's privileges. So there's the absolute privilege as a defense. This is used by politicians or people in court. But politicians, when they are in the parliament, in a debate, in a heated debate, they are allowed to issue false statements in the name of democracy, in the name of the defending people's rights. But in the parliament house, in that debate, not in their personal lives. Okay, so this is viewed as protection for democracy. And there's qualified privilege. Qualified privilege is when there's a special relationship and also there's no malice at all. So the special relationship is usually employment. So let's say the program manager, the program head from this course wants to know about your performance. So they send me an email and they CC you. They want to know about your performance, about your attendance, or about your marks, something about you. And when I reply, one of my statements is false about you. One of my statements is that you are always late, or that you usually don't do your homework, or something that is false and detrimental to your reputation. Or you are under the, you behave as if you are under the influence of alcohol or drugs in the class. So that may be defamatory. But if I do this without malice, if I did it by mistake, and I only issue that statement to the program head, not to the whole class, not to the whole department, not to the whole school, I can be able to use the defense of qualified privilege because I made a mistake. I made a mistake and I issued a false statement. Another example would be when we go to a family doctor the family doctor needs to refer us to a specialist. When they refer us to a specialist, they usually send a referral note. If in the note they issue a false statement about ourselves and we decide to sue them for defamation, they may be able to use this qualified privilege defense. Okay, as long as they don't do this out of malice, they did it out of mistake. Are we good? So those are valid defenses for defamation. Now, I just told you that if the detrimental statement is related to a product, service, or a company, a brand, it's going to be classified as injurious falsehood or product defamation. So you can go online and you can say Tim Hortons coffee is bad, is the worst of all. It's your opinion, it's fine. But you cannot say Tim Hortons coffee comes from slavery farms. Because they don't. If you say that, it's not under public criticism. It is a false statement. It's defamation. Okay? Or injurious falsehood. Now, we're going to look at some other torts. Are you getting the sense on the torts today?
Yeah.
So they are wrongful conducts that cause the victim, that potentially cause the victim damages, losses, injuries. And the victim then, under the law tort, can sue the wrongdoer. Okay? So these are some business-related torts. Now, the first one is inducing breach of contract. Is the tort to induce or to breach the contract? Induce, that's what it's saying there. The tort is to induce, not to breach the contract. To breach the contract is something else. Tort is when someone or a party or a company, they induce someone to breach their contract. Does it make sense? I have a contract with BCAT. The contract to teach this course, for example. Well, that's true. And then another educational institution comes to me and says, hey, João, come teach for us now in the summer. And I say, no, thank you. I love my students at BCAT. How lovely I am. And then they insist. They say, no, but we want you. Come. And I say, no, thank you. If I leave, my students will go on depression. They will start crying. So I'll continue there. And then they come back to me and say, hey, João, we know you are in a contract, but we'll offer you double payment. Double the fee you get to teach at BCAT. And also, we're going to give you 2-week vacation in Hawaii, all paid. You and your family. They are behaving in a way to induce me to breach the contract with BCAT. Because they know I am in contract. I have already said no twice. Right? Okay, I go teach to them. Who was the victim? BCAT was the victim. Who was the wrongdoer?
The person talked to me.
The person that talked to me, the education institution that induced me to breach the contract, right? I was not the wrongdoer, not for the tort, right? So BCAT would sue the other education institution for the tort of inducing breach of contract. Can BCAT sue me?
Yeah.
Yes.
Yes,
For breach of contract.
for breach of contract under a different ground. So BCAT could sue the other education institution for the tort of inducing breach of contract, and they would sue me for breach of contract. Right? Different grounds. Okay, yes.
Can you break that contract and then not go to them and then just be like, oh, I don't wanna work anymore? And then what if you were to go to them like years down the road, because you're not on a contract anymore with that?
If I'm not in a contract, can I breach?
No,
I can breach.
but can you
If I
break the
can't
contract
breach-
without them trying to induce you?
Well, I could, but then it would be solely breach of contract. There's nothing related to the tort of breach. Now, breaking a contract is breaching a contract, so we're gonna look at this in chapter 9. Parties to an agreement, they may breach the contract, intentionally or not. Okay, so here the tort is to induce breach of contract. Could also be that I know a coffee supplier that supplies to Tim Hortons, and I don't want them to keep on supplying to Tim Hortons anymore. I want them to supply to me now, or I want them to stop supplying to Tim Hortons. So I would induce them to stop supplying to Tim Hortons, to breach the contract with Tim Hortons. Could be. Okay, so I gave you an example in employment, also another example in business transactions. Now, unlawful interference with economic relations. So we're talking about economic relations. We're talking about financial, not financial transactions, but we're talking about business transactions in general. Could be supplying coffee, supply of anything. So when a party uses unlawful means, what is an unlawful means? Any means that is illegal, that is not lawful, such as bribery. So if I offer bribery to the supplier, to Tim Hortons supplier, so that they stop supplying to Tim Hortons, so Tim Hortons could sue under the tort of unlawful interference with economic relations. Okay, this is a general tort. So whenever a party used illegal means, unlawful means, they could be sued under that. Yes.
So I think it goes back to the question of whether lawful is moral. So unlawful can also indicate that it's not necessarily not moral. Or is it just that it does not abide by the law? It's not justified by.
It's not about justification, but it's an objective test. Is it legal or illegal? Regardless if it's moral or immoral.
Right.
Because sometimes it's legal, but still immoral,
Yeah.
right?
Yeah.
Sometimes it's illegal, but well, debatable, yeah. So here's more objective, whether it's legal or illegal. So if I use bribery, if I threaten to issue a false statement, so those are illegal things. If I hire someone to threaten or to kill, those things, those are illegal activities.
Yeah.
Okay. Yeah, and then if that unlawful means causes harm to the other, then it's the unlawful means tort. Now, there's the tort of intimidation. So to intimidate, to threaten. Okay, I'll now come here and I say, if I say, can I use your phone? And you say, no, give me the phone or I'm gonna shoot you. This is just an example. This is right. Of violence, just an example, because I don't have the gun with me today. I don't have guns.
We didn't hear that.
So, yeah. So you don't want to give me the phone, but you're just giving me because I am threatening you. Well, this is more given on the phone, but the example here is if I threaten you, and by threatening you, I am forcing you to do something that harms you. So this is more of, let's say, my phone. Let's say my phone is causing shocks or electric shocks, or it's hurting me. So I threaten you to use my phone. That's gonna cause harm to you. So you could sue me for intimidation. Okay, you only did that and you suffered that harm because I threatened you to do that. Okay, it's a little bit different from deceit, because here there's a threat of violence. There's a threat of a serious event in intimidation. In deceit, I'm fooling, I'm deceiving the person. So let's say there's something here that is gonna make you sick. So I tell you, drink it. And you say, no, I don't want to. Say, no, drink it, it's delicious. So here I'm not threatening you to drink, but I'm just saying that, hey, you should drink it, it's really good. But I know it's not good. I know I put something in here that's gonna make you sick. There's this recent case in Brazil from last week. The wife was it the wife or girlfriend? I don't remember. She prepared chocolate cake, and she put poison in water. And the husband or the boyfriend died. So it's like deceit. It's a criminal offense also, but in terms of compensation, tort, she convinced him to eat something she knew was bad, was poisoned. Okay, so that's the deceit. You are deceived. Now, intentional infliction of mental suffering. Well, when someone intentionally inflicts you to suffer mentally, this is common, not common, but this could happen when the boss, when the manager, they yell at the employees, they disrespect employees. So employees may develop mental suffering, mental anguish. I'm not going to use examples of instructors because instructors never do this. Instructors are perfect. Instructors never make a mistake, right? I'm joking. To be that instructors disrespect students and then they inflict in students of mental suffering, right? So unfortunately, after COVID, there's a lot of mental suffering taking place. Many people. So this is a tort. And I'm saying here it's related to intimidation because sometimes as a consequence of intimidation, you may also develop mental suffering. So you could sue under those two torts together, as long as you can prove in court you suffer those damages. Now, conspiracy to injure. Because it's conspiracy, it requires two or more people or more parties. Because two or more parties, they are acting together. This is to conspire, to act together. To act together to injure the business interests of someone else. Can you think about an example? Let's say there are 5 coffee shops Burnaby campus. 4 of them, they conspire together to injure the 5th one. So they conspire together in a way that the coffee will be priced at $1. Very cheap. Because they want to cause bad to the 5th one. They want the 5th one to go bankrupt. Because their coffee is $3, $4, $5.
I think they're going bankrupt for sure than $1.
Maybe, or maybe they have money available, but the thing is they are conspiring to cause or to injure the business or interests of someone else. In my country, unfortunately, this is common with gas station. Gas station groups, owners, they fix price so that they offer slightly lower than others, so that the others go out of business. Excuse me, this is known as cartel. Cartel is fixing prices. This is illegal. This is against competition. Okay, cartel. Passing off. What is this? Passing off is, let's say I start a coffee shop. And my coffee shop is Tim Hortons, but Tim with N, not M. Tim Hortons. Or without the S, Tim Horton. And it's also red. Not the same, but similar trademark. So apparently I am trying to capitalize under Tim Hortons goodwill. I'm trying to pretend I am connected to Tim Hortons. So I'm trying to show the public we are connected, but we are not. So Tim Hortons, they could come after me based on the tort of passing off. Well, Tim Hortons could also come after me under trademark infringement because they have a registered trademark. But companies that don't have a registered trademark, they can't sue for trademark infringement, but they could sue under the tort of passing off. Okay? Yes.
You have the bits here.
Yes.
They write in the cup we produce Starbucks.
Yeah, I think they offer Starbucks products actually.
Yeah,
But yeah,
They're acting in.
Yeah, in principle, if they actually offer Starbucks products, Starbucks may have given them the license. But if Starbucks hasn't given them the license, that would be Starbucks could sue under passing off, but most likely under trademark infringement, because when you have a registered trademark, the damages under Trademark Act, they are higher than the passing off. But we don't know. This is something that Starbucks would have to investigate. Okay, it seems they offer Starbucks coffee, but yeah, that would be a good example. If they were using Starbucks trademark without Starbucks authorization, using a different coffee, that's a very good example, which I'm not sure it is the case. Okay, that's a good one. Now, misuse of confidential information. The tort is to misuse confidential information.
Blackmail?
Blackmailing is a tort in itself. How do we know information we receive, we obtain, is confidential or not? How do we know it's confidential?
Private information.
Could be,
Private information is usually confidential. Okay, but what else?
could be about products that are proprietary.
Okay, but information itself is not proprietary. The information itself. It's an advantage for the company because they keep it secret. Right?
I think we can use,
But
that-
in those lines, yes.
we can use that information to cause harm, then it's confidential.
If I receive confidential information and I use it, I misuse it and cause harm, yes, it's the tort. But initially, now let's say you share a recipe with me. Recipe.
I don't know.
You don't know what to cook. Me neither. No. Well, I can fry eggs. No, I can cook some meat.
Container?
Yes. Huh?
Mac and cheese?
Mac and cheese? Well, just if the instructions are in English and very detailed. So you share a recipe with me. How do I know it's confidential information or not? Do not overthink. We're not in law school. Straightforward. How do we know? Okay, because I trust, but
Because they're the owner of the information.
there's no ownership in the information. But okay, usually we don't know, but I'm telling you, there's no proprietary rights in the information itself.
Because he is a cooker.
Like this? Say it's confidential.
If you say it's confidential, we have to be told information is confidential unless it's private. We have to be told. That's why in email, sometimes in the bottom, there's a confidentiality notice. Information in this email is confidential and addressed to this free only. If you're not yet received, please delete it, etc. Now, sometimes documents in the very top, confidential, or there's a watermark, confidential. So the basis is whoever has the information, they are not the owner, but they have it. They have to inform that whatever they disclose or what they are about to disclose is confidential. Then it becomes confidential information. So you come to me and say, João, I have a confidential recipe to share with you. You share with me and I start a restaurant based on your nice recipe.
No,
Because you shared with me under confidence, you could sue me for misuse of confidential information. Right? And to help you prove in court, you should put that in writing. You should have in writing, you could email me or even print, but then there will be a sign of confidential. We could also sign an agreement, a contract that is called confidentiality agreement or non-disclosure agreement. Those are known as NDAs or CDAs. If we sign, we are talking about business. So I have the money, I'm the investor, you have the recipe, and you have many other recipes. So we sign an NDA, meaning that all information we exchange is confidential. You cannot misuse my information or the information I share, and I cannot. So this is a mutual confidentiality agreement. Right? So to start with, unless the information is private, like I have access to your private information. I have access. Even if you don't want to, but I have access. I know what your registration number is at PCAT. It's private information. But I know I have access to some private information of yours because of my job duties. And because of my job duties, I cannot misuse confidential information.
You can share our information.
No, I can't. I can share as long as it's part of my job duties.
Other instructor.
Exactly. Yes, but I cannot sell your information to marketing companies and etc. No, I can't. Okay? So keep that in mind. We can only commit this tort, misuse or improper disclosure, if we were told or informed verbally or in writing that the information we were about to receive is confidential. Okay? All right, so this is from the publisher. I just kept it for you. You have a summary of all torts we went through: assault, battery, trespass to land, chattels, conversion, deafening, false imprisonment, malicious prosecution, private nuisance, defamation, injurious falsehood, inducing breach of contract, unlawful interference with economic relations, intimidation, deceit, conspiracy to injure, passing off, misuse of confidential information.
These examples are those.
No, it's just a summary of the torts. Okay? Summary, yes, and you have some details as well here. So when you are studying, if you want, you can add the available defenses here, right? But this is good for you as a summary if you want to. Now, to finish, we'll talk about privacy. So when we talk about privacy here in this lecture, we're only talking about the torts related to privacy. I'm not talking about privacy as a legal topic, okay? Privacy as a legal topic is much broader. So here I'm just talking about some torts related to privacy. So the first one is invasion of privacy. So invasion of privacy is usually online, but can also be physical. When you were to when we had a break, you went to the washroom. I checked your files in your PC, in your laptop. This is a physical violation of privacy. If you check my phone is unlocked, and you check the pictures I have, any information that is there, it's a physical violation of privacy.
Is it still under tort?
It's tort. Yes, it's the tort of invasion of privacy. If you have a drone and you intentionally take pictures of your neighbors in their private affairs, violation of privacy, right? So those are examples of either physical or online violation of privacy. Okay. Also here, using image or name or accessing information. Now, there's legislation, there's law about privacy. There's the BC Privacy Act. The BC Privacy Act is a very good one. The BC Privacy Act is the one that allowed this lady from BC to start a lawsuit against Facebook. Facebook was sued by the lady from BC, and then it became a class action. I think I showed last Wednesday for those who were paying attention in the online lecture. So that became a class action. Facebook settled, remember, for $51 million, and based on the BC Privacy Act. Okay. Now, there's federal and provincial legislation. One other tort that has been recognized in Ontario and in the US too, but not in BC yet. So if it's not recognized in BC yet, it means that courts in BC may recognize in the future, but it's not mandatory required in BC. So it's the tort of intrusion upon seclusion. So this is when someone intentionally intrudes, could be physically or otherwise. That case was someone who had access to someone else's bank statement, private affairs, in a manner that is highly offensive to a reasonable person. So it's highly offensive to us if someone else is looking at the millions, the billions we have saved in our bank accounts, right? It's very offensive to us. So we could sue for the tort of intrusion upon seclusion there in Ontario or in the US. Okay, so that has been recognized. Another tort related to privacy is the tort of spoliation, which is destroying evidence, deliberately destroying evidence. So you have access to sensitive information, important evidence that could be used in court, and you intentionally destroy it. That's the tort of spoliation.
Does it have to be where you come to the court and then they do that, or can it be before?
Or can be before, can be, if it was already, if you knew that would be used as evidence and you destroyed it intentionally, you could be sued, yes. All right, so with regards to online torts, well, there are torts that are regular torts, normal torts, that they are also applied to the online world. So like invasion of privacy. Invasion of privacy can be physical, but can also be online. Okay, but as I told you in the very beginning, torts, they constantly or regularly, they recognize new torts. Because I didn't mention to you in the beginning, by the way, I'll mention now. Primarily, not only, but primarily tort law is based on judge-made law, is based on case law. Yes, there's written law for torts, but most torts, they are primarily from courts, judge-made law. So courts are regularly recognizing new torts, okay? Creating or recognizing new torts. They may also recognize online ones. So summarizing, we looked at the law of tort. What is the main objective for the law of tort? To compensate victims. It's to allow victims to be compensated, to be able to sue in court and be compensated. What is vicarious liability? Okay, yes, an employment relationship, it's a good example. So it's liability without fault. Okay, but they are still liable. Protecting the victim, yes. So intentional torts. In intentional torts, does the wrongdoer need to intend harm?
No.
No, intention of harm is irrelevant. It may happen, and the more you harm, the higher the compensation, but the tort will be committed based on the act, not based on the harm it caused. So they are intentional torts. So we went through several torts, right? Several intentional torts, and then we just finished talking about some privacy torts. Questions? Comments?
Oh, I have a question.
Yes, please.
When are we getting our team?
Oh, teams. Are they not available yet? Okay. Just stop the